My brief intro, I'm an immigration attorney. I work mostly employment-based immigration. So I work with US companies that are hiring international individuals on visas to come work for those companies here in the US, as well as international entrepreneurs and foreign startups who want to bring their business to the US and have to get a visa to do that. I help families, marriage-based immigration, investor visas, citizenship, green cards, that whole thing. That's my spiel. I have a very short amount of time to cover an incredible amount of material tonight. So I'm going to go really fast, okay? And I am so certain everyone is going to have questions on what I'm talking about. So if we can, we'll hold it for a whopping 5 minutes of Q&A, but I will stay here until they kick us out and answer your questions thereafter. If you have questions in the back of the room. I also have cards there. If I'm boring you or this sucks and you want to leave, feel free to take a card. Or, and again, this is not going to be comprehensive. So if I have a question or I'm not clear on that, we can always chat about it later. Cool? So that's my introduction. Yeah, is this going to work? No? No?
That's my fault.
No worries. Oh, we're going to switch slides.
There we go.
Technical problems. Yeah, so again, we're going to be talking about a lot that's changed within immigration law, and we're really only going to focus on employment-based immigration law because if we talk about everything that happened in immigration law in 2017, again, we could be here until next month. But I want to start off first by talking about what concretely has changed for immigration law from 2017 till now, which is the beginning of January 2018. In April 2017, President Trump came out with an executive order called Buy American, Hire American. Okay? The Buy American, Hire American executive order did not change any immigration laws. But what it did do was it directed the Department of Homeland Security and U.S. Citizenship and Immigration Services, USCIS, to do everything they can in their power to ensure that the U.S. immigration laws are protecting American workers and to make sure we're only bringing over the most highly talented people to this country. So it did not change immigration laws in this country, okay? The president does not have the power to actually change the immigration laws in this country. It takes an act of Congress to do that. But with his limited executive power, he can direct these agencies to do things to make sure we're protecting American workers. And so through that, we saw an increase in the visa scrutiny in a number of different ways, in a number of different policies in 2017, okay? We saw that, first off, from a tech perspective, early in 2017, with H-1B visas, which we're going to talk about in much more in depth in a little bit, but for computer-related occupations. So programming occupations, certain programming occupations, used to be falling within the H-1B visa guidelines, and now the U.S. Citizenship and Immigration Services have this policy to look at certain programming positions, we'll talk about that in a bit, as not qualifying for H-1B visa, for an H-1B visa because they're not considered a specialty occupation, meaning that which requires a bachelor's degree to perform, okay? That was the first thing we saw. Second thing we saw last year, and this was not only with H-1B visas, but with all visas, a massive increase in requests for evidence, RFEs. It was somewhere in the ballpark of a 40 to 50% spike in USCIS's requests for additional evidence on visa applications that were sent to them. Meaning, hey, we can't approve this yet, we need more documentation, we need more information on that, okay? The third thing we saw that came out as a policy was, and we were talking about this actually before we started this, was USCIS no longer gives deference to visa extension petitions. Okay? It used to be the policy that if you already had a visa approved and you were applying to renew or extend that visa, they would give deference to your prior approval and say, okay, you know, it was approved. We give that credence when we're adjudicating your extension. Now the new case is each individual petition is adjudicated separately. We don't care that we approved this previously. We're now looking at each one of these separately, okay? We saw extreme vetting occurring at consulates outside the US. And the extreme vetting in the employment-based context is really much more in-depth on your employment history. What really were you doing prior to this? Looking more at your education credentials. And additionally, and you probably heard this on the news, we want to see your social media handles. We want to see what you're saying. Now, what is the real purpose of that? Probably to make sure you're not making any terroristic threats, you're not a criminal, you're not doing anything illegal. But they're looking at those. And what's ultimately happening as a result of that is we're having a slowdown in the visa issuance process, and that's impacting employers and international individuals as well. So that's what concretely did happen in 2017, quickly in a nutshell. What do we see on the horizon now for 2018? Okay? More scrutiny and more enforcement on high-skilled immigration. It is a couple weeks ago, the end of December 2017, there was a memorandum from the administration that said, we intend to increase a scrutiny on high-skilled visas. We intend to do this under that Buy American, Hire American executive order to make sure we're protecting American workers. We're going to see probably more RFEs as a result of that. For entrepreneurs and startups, under President Obama, he came out with a rule, or he instituted a rule called the International Entrepreneur Rule, which would allow foreign entrepreneurs who were making an investment of about $250,000 into an entity that has been in existence for 5 years, that they were going to come run, to get what's called a parole, which is not actually a visa, but it provides them work authorization to come to the US to work for that entity. What happened when President Trump came in office is he kicked the can on that. He didn't institute the International Entrepreneur Rule. And all the way until the end of 2017 did he say, okay, never mind, we're going to rescind that rule. Well, because he's not the brightest guy in the world, he forgot out of a technicality to not properly rescind that rule. So as of today, in this moment, the International Entrepreneur Rule exists. However, he has said, yeah, I messed up on that technicality, but don't you worry, I intend to rescind that rule, and the International Entrepreneur Rule will no longer exist, probably sometime in 2018, okay? Last thing, foreign student work authorization. Most students, after they graduate, get what's called optional practical training, OPT. Gives them a card to let them go work wherever they want for up to 12 months after they graduate. Certain students who graduate with science, technology, engineering, and mathematics degrees, STEM degrees, actually can extend that 12 months for an additional 24-month period for 36 months of work authorization. That rule was a President Obama rule. President Trump says, I don't think so. He has made it his intent, it's not currently the case, but he said it is his intent to do away with that STEM OPT extension to allow for an additional 24 months of OPT for those individuals. Employment versus not employment. This has become the big hot button issue in 2017, especially for technology companies that are usually bringing over foreign nationals to come over and engage in meetings or conferences or speak to investors or to network. The administration has gotten very, very strict on the definition of employment versus not employment. Employment means you need a work authorized visa to come here and work. If it's not employment, you don't need a work authorized visa to come here to work. You can come on a tourist visa, or you can come on what's called the visa waiver program. Certain countries are exempt from actually getting a visa, and they can come with this visa waiver, okay? These are all non-immigrant visas that we're about to talk about. Non-immigrant temporary work visas here in the US, okay? Some provide work authorization, some don't. If you're coming here, and it used to be, oh, I'm a businessman, or I'm coming here to talk to potential investors, or I'm coming here to engage with opportunities, you could come on one of these tourist visas and it wasn't a big issue. We have seen a massive trend in 2017 of officers at airports going, stop, give me your cell phone, let me look through your email, let me see what is the exact purpose of your visit here to the US. If I think you're coming here to do work and you don't have a work authorized visa, bye-bye, go home, okay? They're becoming very, very strict, so it's very important for employers to know that if you're bringing someone to come here and engage in work. And work for immigration purposes, this is Jason's definition, work for immigration purposes is anything that a normal person would get paid to do regardless of whether you're being paid, okay? So oftentimes I get calls, people saying, well, this person's gonna come here, they're gonna do some programming for us, but they're not gonna be paid. Sorry, USCIS says that's work, because a normal person would get paid to program. They need a work authorized visa to do that, okay? So, the B1 visa, which is a tourist visa to come for business purposes, allows you to come for up to 6 months at a time. The visa waiver program for individuals who are from certain countries can come to up to 3 months at a time, but they can't work, okay? They can't be gainfully employed. You can come, you can attend meetings, you can network, you can talk to investors, you can look at office space, but anything that a normal person would get paid to do is work, and they're becoming very, very strict on that. The other thing they're becoming very strict on is proving your intent to return back to your home country. So it's one thing to say, hey, I want to come, maybe I want to check out some jobs, maybe I want to see what opportunities lie here. Well, that's one thing. It's another thing, can you prove your intent to return back to your home country? It's another hot button area that they're cracking down on. The H-1B visa. So quick synopsis for those who don't know what the H-1B visa is. H-1B visa is a temporary work authorized visa in the US. It allows a US employer to sponsor a foreign national to work for up to 3 years, plus a 3-year extension thereafter, 6 years, in what's called a specialty occupation. Specialty occupation is one that normally requires a bachelor's degree to perform. So most tech jobs, programming jobs, software jobs, hardware jobs require a bachelor's degree to perform. Coming to be a janitor or coming to be an administrative assistant probably doesn't require a bachelor's degree and wouldn't be an H-1B qualifying position. Second criteria is the foreign national actually has a bachelor's degree that relates to the job they're going to be performing. Okay? That's the general requirements for the H-1B visa. Each year, USCIS makes available 85,000 H-1B visas for everyone in the world to apply for. And they make them available usually on the first Monday of April. This year it's going to be April 2nd, okay? If the company that's applying for that foreign national gets one of those H-1B visas, they apply on April 2nd, it becomes active to use starting October 1st, okay? April 2nd apply, October 1st it becomes active, okay? What happens, and at least in the last 5-6 years, is on the very first minute of the first Monday of April, or April 2nd, USCIS receives in excess of 85,000 H-1B visas. So what do? Uh-oh, got a big problem. We got way too many visa applications for only 85,000 available visas. We're gonna have a lottery. We're going to take all those visas that we receive, usually in the first week of April, and we're going to put them in a computer-generated lottery system. We're going to let a computer select at random the 85,000 H-1B visa applications that they will then hand process. If that visa is approved, it can begin work on October 1st. If it's not selected, it's sent back to the employer. Sorry, try again another year. Okay? Any guesses last year, 2017, how many H-1B petitions USCIS received in the first week of April? No. No. I guess it's about 199,000, a little over 199,000, okay? So mathematically, there's some math people in here, less than a 35% chance of getting one of those visas, okay? Now, it's a completely fair lottery. Everyone's weighted the same. Doesn't matter if you're working for, the Dell or the one-person startup here. Doesn't matter if your nationality, doesn't matter the position you're working in. Everyone's weighted the same, okay? Now, out of that 85,000, they actually set aside 20,000 for individuals with U.S. master's degree, okay? So if you have a U.S. master's degree or higher, you get kind of 2 bites at the apple, okay? You get to play with that first 20,000. If you're not selected, you get to play with the remaining 65,000. That's the only caveat in there, okay? So the key thing is April 2nd is coming up. Those employers that are looking at hiring H-1B individuals need to start preparing now. There's a prerequisite filing that has to be done before you can file. The applications can't go in before, can't go in after April 2nd. They have to be in on April 2nd. So employers should start preparing now to figure out who they're going to hire and get those materials together. Potential changes to the H-1B visa. This is what we've been hearing about a lot since President Trump took office. He's had an intent to rein in the H-1B visa program, which is an old, antiquated program with 85,000 visas for 199,000 people that want to apply. So, several weeks ago, at the end of December, he came out with another memorandum that said it is his intent to, under Buy American, Hire American executive order, to rein in this H-1B visa program. How? Redefining the eligibility requirements. He hasn't said specifically what he wants to do, but he wants to make sure the program is rewarding those with the most education, those that are being paid the most, okay? He's also talking about revising the lottery system so that perhaps those that have higher education are weighted higher in there. Again, we don't know the specifics, but this is what we feel like could be on the horizon. Eliminating what's called the H-4 spouse employment authorization, okay? Right now, in limited circumstances, spouses of H-1B visa holders can work in the U.S., and he's talking about removing that program for them. Lastly, extending H-1B visa extensions beyond 6 years. Again, when certain individuals are here with green cards and they've been waiting for a long period of time, in certain circumstances, they're able to extend their H-1B visa beyond 6 years. He's talking about removing that program as well. Okay? I'm getting short on time now, so I'm going to run through really quickly some of the other options. Again, all of these are going to be highly scrutinized in 2018 because of the current environment we're in. L1A is for foreign nationals that are intra-company transferees, executives and managers, those who've been working outside the U.S. for 1 out of the last 3 years and want to be transferred to a U.S. entity, or foreign entrepreneurs that want to set up their own U.S. entity that they've been working for outside the U.S. E1 and E2 for foreign treaty traders and treaty investors, certain countries that have a treaty with the U.S. That are coming to engage in trade with the U.S. or make a substantial investment in the U.S. can get an E1 or E2 visa. None of these, by the way, are subject to a lottery. None of these are subject to a cap. They can be applied for at any time during the year. O1 for foreign nationals of extraordinary ability, those who reach the sort of top of their field, can be eligible for an O1 visa. The TN visa for Mexican and Canadian nationals only that are coming to work in limited occupations. And that program also may be on the chopping block, as we've heard in the news. The president has issues with the NAFTA program, and the TN visa program is part of the NAFTA program. So if the NAFTA program goes away, so does the TN visa. And the E3 for Australian nationals only who are coming to work in professional occupations. Lastly, U.S. permanent residency. Again, these programs are also going to be probably experiencing some change in the U.S. Several general ways of obtaining U.S. permanent residency, either through family, marrying a U.S. citizen, or a lawful permanent resident, or bringing over children or relatives. Employment-based. The employment-based permanent residency does require, however, that a U.S. employer go through a test of the U.S. labor market to prove there's no qualified, able, willing, or available U.S. workers that can do what the foreign national can do. It can be a long process. And the EB-5 program for foreign nationals that either are investing $1 million in a U.S. enterprise that's going to create jobs for 10 U.S. workers, or $500,000 in sort of targeted employment areas, also creating jobs for 10 U.S. workers. Those amounts, $1 million and $500,000, are also expected to go up as well. Okay? We're good on time. I rushed through those last slides super quick. I'll give that some extra time then for Q&A. Okay, perfect. Does that sound good? Yep. Go ahead, questions. Anyone? No? Yeah. Sure.
Any changes coming for the E1 and E2 visa?
The E1 and E2 visa? I don't see any. So there's no, the question was, are there changes on the horizon for the E1 or E2 visa? I don't foresee right now any changes for the E1, E2 visa, except for the treaty countries. So the E1, E2, you have to be a foreign national of certain countries that have a treaty with the U.S. Certain countries, surprisingly, that don't qualify right now: Brazil, China, India, Russia, Israel, and a host of other countries do not qualify for that E1, E2. So perhaps some of those other countries will become E1 or E2 countries. But I don't see the program itself changing. Now, what we did see in 2017 was USCIS's definition of a substantial investment that's required for the E1 or for the E2 visa. And so it used to be substantial was relative to what the business was. So if you were coming to start a food truck, it would be much lower, as opposed to a semiconductor fabrication facility where it would be much higher. We're seeing those amounts that they deem to be substantial raising significantly. Yeah. More questions? Yeah.
I'm curious, which visa brought Melania over to this country?
H-1B. And an H-1B visa for models. Yeah.
So,
Yeah.
for stopping H-1B visas beyond 5 years, does it have to go through Congress or can that be done something could be?
Yeah, so your question was changing the length of time for the H-1B visa. Does that have to be done through Congress or can that be done by the president? That has to be done through Congress. So changing the fundamental rules of that law can only be done by Congress. Now, certain things like extending that H-1B visa beyond 6 years was done by executive order because that program allowed people who were waiting decades sometime for a green card to continue to renew their H-1B visa can always be undone by another executive order. Yeah.
If somebody is on an H-1B visa for the maximum period of 6 years and he goes back, what happens to the taxes and Social Security, Medicare that he has paid for 6 years?
Comes to the government. What's that? Period. Yeah. Yeah. I wish I had a more robust answer for that, but that's it. Yeah. Go ahead.
What is the possibility of starting a startup on H-1B visa?
Yeah, that's a super important question. His question is, what is the possibility or how is it done, a startup on an H-1B visa? It's a long answer to that question. The short of it is, it's possible, but the way USCIS adjudicates startup visas for small companies where you are an employee of the company is what's called ownership and control. So if you have a startup, you have to show that you don't control the company, or you don't own the company, so someone else owns at least 51% of the company, not you, and that someone else controls you as an employee. So there has to be someone here, because it's an employer-sponsored visa, the H-1B visa, who says, it's not your company, it's my company, I own it, and I'm hiring you as an employee. I have a contract that says when you can come to work, when you can go to lunch, when you can take vacation, what you can wear, so on and so forth. So there's that ownership and control issue. If that can be established, then it's possible, so long as you can show what's called that required wage, which was in that slide before. The employer has to pay you the required wage, which is set forth by the U.S. Department of Labor.
I cannot be part of the benefit of the company, right? Whatever revenue they're generating there.
I didn't understand your question.
I'm like, if I'm working as an employee still, I cannot be part of like the revenue or benefit, right? Like I cannot own any percentage in the company.
You can, so long as it's less than 51%.
Okay, I can have 49%.
Sure. Now, you can, but under this Buy American, Hire American, if I'm the mean, nasty immigration officer, I may take some issue with that. There's nothing to say that that's illegal. That's totally fine, because we can say someone else owns that company, but an officer may take issue with that. Are we good?
Last
We did-
question. Yep.
Yeah, so adding to that question, the H-1B visa is not tied to the company, correct? I need the company to sponsor my H-1B visa, but once I started the job, I can switch companies, right?
Correct. Once the foreign national has an H-1B visa, if they're terminated or they quit, they can move to another employer. There's a grace period. It's usually 60 days to find a new employer. And in that time, you can move to that new employer. That employer has to file a whole new H-1B visa for you, but you don't have to go back if you do it there. Now, even if it's beyond 60 days, you would go back, and another employer, let's say 6 months later, wants to hire you, they could do that, and you could then use that H-1B visa. You wouldn't have to go through the lottery again. Cool? We're done? Awesome. I'll hang around if anyone else has questions. Thanks so much.